A very warm welcome to lesson number 32 in our 50-part series on the law of evidence. In today's lesson, we will be discussing the relevancy of the opinions of third persons. For this, we will be seeing the sections from section 45 up to 51. So again, to remind you, we are presently dealing with chapter 2 of the Indian Evidence Act, which deals with the relevancy of facts. Okay, so within this chapter in the Bare Act, you'd find various subheadings. So the subheading that we are dealing with presently is the opinions of third persons when relevant. Now, as you can see in the sections that you find within this subheading, you can see opinion, opinion, opinion. So as you can see, this is about opinions, which means that it is perhaps good for us to spend some time first understanding as to what an opinion is. In fact, before you proceed any further, I want you to pause the video and give it a thought. I want you to think about why the word opinion has been treated differently, as to why there is a separate section, a separate subsection, a subpart, wherein opinion has been laid so much emphasis upon. So, talking about opinion, if I were to ask you as to what your opinion is, how is that different from something else? So what is it peculiar about an opinion that makes it different from, say, something else? Let us say, if I were to ask you your opinion about something, what is it that I'm seeking from you? Am I seeking from you fact? Or am I seeking from you something that is closer to a judgment? I hope you realize this point, that an opinion, for example, when you seek a medical opinion or a legal opinion, this itself kind of connotes somebody's expertise, somebody's knowledge that is then applied and then given to you as a bit of a conclusion, right? An opinion connotes something like a conclusion. It connotes some sort of expertise. In other words, it is not simply a fact. Now, particularly in the case of the law or in the court, who is the person who is competent to form an opinion? In other words, a relevant opinion, because anybody can form an opinion. But who is the person who can form a relevant opinion while you're in the court? As you know, that person who is entitled to go for that opinion is the judge, right? So the judge decides, and the judge in his or her opinion decides as to who wins the case. For example, once the court has appreciated the evidence by using what we understand as judicial wisdom, right, or the wisdom of the court, as we say. Once the court has exercised this judicial wisdom, it basically pronounces its conclusion, and that conclusion is basically the opinion of the court. You'd in fact find that several times in judgments, the courts, you would find that judges use this. We are of the opinion that. So you'd often see this in judgments. We are of the opinion that whatever, right? So as you can see, an opinion is kind of a conclusion, and that in the court is the prerogative of the judge. So what is it that the witness is supposed to do? He is supposed to discuss facts. So I hope with this brief discussion, you are clear about the distinction between what is merely a fact and what is an opinion. Essentially, a witness comes to the court, and when he does so, he gives oral evidence. Okay. Now, oral evidence is required to be direct, which means it should come from the person himself. We know all of this, but what he speaks is required to be a relevant fact. Okay. He cannot give his opinion on what he thinks. He cannot give his conclusion. He cannot provide his inference. He only presents the facts to the court. Okay. The court forms the opinion on the basis of these facts. Okay. So remember that ordinarily a witness is not allowed to offer an opinion, which is what makes this part from section 45 to 51 special, because in this case the opinions of third persons are relevant. So opinions become relevant. So this is why opinions are special when you see them in this category, because ordinarily a witness is not permitted to present his opinions. he is required to present the facts. However, in these cases that you find between 45 to 51, you can present your opinion before the court and that would be relevant. I think we all are fairly acquainted with the opinion of an expert. We have all heard of this. So we always seek the opinion of an expert before taking a step, whether it's a medical expert, a legal expert, whether it's for architecture or whatever, we seek the opinion of an expert. Why? Because he has some expertise and it is important for us to be able to factor in that while making our decision. So you of course know what an expert is, but this is an excerpt from a judgment, so you can see as to who an expert witness is. When you have a cursory glance at section 45, what you can see immediately is that section 45 is the kind of section that declares certain kinds of facts to be relevant. As you can see at the end, it declares that certain kinds of facts are relevant. Now, you probably already know, we've discussed this several times over in the previous videos, that the provisions between 5 and 55, which is basically chapter number 2, they either declare a certain set of facts to be relevant or they declare them not to be relevant. So clearly, section 45 falls in this category, which declares certain facts to be relevant. Now let's go ahead and see as to what is declared to be relevant in section 45. So it says that when the court has to form an opinion upon a point of foreign law, science, art, or as to the identity of handwriting or finger impressions. So remember these fields, because this is very important. It is specific only to these fields. The fields being foreign law, science, art, or as to the identity of handwriting or finger impressions. Then the opinions upon that point of persons specially skilled in such foreign law, science, art, handwriting or finger impressions are relevant facts. What does that mean? So when the court has to form an opinion, on these subjects, then the opinions of experts are relevant. What does that mean? Evidence can be given for this, okay? Which means, let's say there's an expert can talk about it. An expert can give evidence for it because it is relevant. If it were not relevant, then no expert could have come and give his opinion to the court. It's quite obvious as to why we have this provision here, because specialization is needed, specialists are needed, because the court handles matters of all kinds. Therefore, the inputs from a specialist will help the court take the right decision. Let me give you a couple of examples. Foreign law. The Indian court, the local court, may not be well versed with the foreign law, and therefore assistance from an expert of foreign law would help the court. Perhaps you've heard of this word called amicus curiae. You must have heard this phrase. Amicus curiae. Perhaps I've pronounced it wrong, so pardon me. So this basically translates as friend of the court. So the court often takes the help in some matters from people who know their subject. They may be helping the court on law or on fact. So the court incorporates what these people have to say. And of course, that happens as experts. Their opinion becomes relevant. Okay. For science, it's quite obvious that all of your forensics and all of this comes under science. Art. Let me give you an example. Let us say someone complains that there has been a copyright infringement of somebody's song. Okay. Now this is an artistic work. Maybe the court may not be able to understand as to what the musicality or what the intricacies of that music was, but maybe an expert would know whether it has been copied or not. Okay, whether there has been any such kind of infringement of intellectual property. So there the input of an expert would help. And of course, I think it's fairly easy to understand as to why handwriting and fingerprints would be important. This section also tells you as to who an expert is. It says such people are called experts. So according to section 45, basically persons specially skilled in these 5 domains, as you see here, are experts according to section 45. This section is fairly simple to understand, so you can have a look at illustration A. It's clear here that the opinion of an expert in the field of science has been sought here. Now look at illustration C, again to section 45. The question is whether a certain document was written by A or not. Okay, so now you have two documents, okay, and now you have to compare and see if both of these were written by A, for which you need an expert. So obviously this time the expert is in the field of handwriting. So as you can see, it has to pertain to one of those 5 fields that are mentioned in section 45. So we just spoke about handwriting in section 45 in the illustration C. Now look at section 47, and it is very important for you at this point to pause the video and then look at section 45 and section 47. Again, the court has to form an opinion about handwriting. Handwriting has already been discussed in section 45, and as I've emphasized several times over, there is no needless repetition in a statute, right? That would become redundancy, and a statute is meant to be as brief, concise, and brusque as possible. Therefore, it will not engage in unnecessary repetition, which means that when you find a new provision, you must always know that some new point or different point would surely have been introduced. So I want you to see as to what is different. How is 47 different from section 45? What is it that section 47 speaks of that is not spoken of in section 45? Pause the video and try to make sense of it by your own self before proceeding any further. So if you'd paid a little attention, then the difference is pretty simple and straightforward. Section 45 talks about an expert of handwriting, right? And section 47 again talks about handwriting, but about someone who is acquainted, right, with that handwriting. This person need not be an expert. Let me give you an example. A handwriting expert perhaps would be able to comment about an absolute stranger, right? So perhaps a handwriting expert could see 2 pieces of handwriting and then conclude that, okay, this is the same person. Or maybe on the basis of the handwriting, he might be able to conclude as to whether this person was left-handed or right-handed, and so on. Okay. On the other hand, section 47 deals with the case when a person is acquainted with the handwriting of a particular person, although he is not an expert. Say for example, my friend from school who shared the table with me right from 1st standard till 12th standard, that person would know my handwriting. He would be acquainted with my handwriting, not because he's an expert, but because he's had the means to see my handwriting, and one such person can surely recognize my handwriting. So when the court has to form an opinion on whether a certain document has my handwriting or not, it can either seek the help of an expert or it can seek the opinion of this friend of mine. So that is the difference between section 45 and section 47. Now let's have a look at section 50. Opinions on relationships. So people often have opinions on relationships, right? It's one of the best topics that people have. Opinions on people's relationships. So generally this kind of gossip is not relevant. However, it can be relevant under special circumstances. I'll show you as to what that is, and when it can be relevant, I'll give you some examples. But first, let's read the provision. It says that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who is a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. So again, we always know that the court is the person who has to form the opinion finally. So the court requires to have an opinion. Opinion on what? Opinion on a relationship, right? So always remember, the opinion is formed by the court finally. But for the court to have this opinion on the relationship, it might need the assistance of someone else, which means that to help the court form its opinion, the court may need the opinion of someone else. So in section 45, we saw that it looked at the opinion of an expert. In section 47, it saw the opinion of someone who is acquainted with the handwriting. So now when we see section 50, it seeks the opinion of a person who has special means of knowledge on the subject. Who has special means of knowledge on the subject. Okay. What is the meaning of special means of knowledge on the subject? Let us say this is a house, okay, and there are two people living here. Now, what is their relationship? Maybe there is somebody who lives here in this house. Maybe there's someone who lives in this house. But there's someone who also shares this wall here and someone lives here. Now, this person can put his ear to this wall and he can listen to what these people talk. So he has special means to knowing as to what the relationship is. Let me give you another example. Let us say somebody is a very close friend or a family member, as you can see here. Because somebody is a family member, he has special means of knowing. As a family member or maybe as a security guard. So sometimes security guards know a lot about people and their relationships. So this also is a person who has special means. The domestic helps, the maids, well, they also know a lot. So all of these people have special means to know as to what the relationship between people is. Okay. So the opinions of these people who have special means, because basically they're experts on that subject. But you don't call them experts because you use the word expert only for those 5 fields that were given in section 45. So do not call these people experts. These are simply people who have special means to have the knowledge on the relationship. So their opinion becomes relevant under section 45. Take a moment, pause the video, read this carefully and try to make sense of it. Let me now talk to you about why the opinion on a relationship might be important. Why does the court want to form an opinion on relationship at all? Okay, let me give you a few examples. Let us say you want to talk about alimony, which is basically maintenance after divorce, or maybe because people are no longer living together. So alimony can be claimed only if there was a relationship similar to a matrimonial relationship. You might also be aware that it does not have to be a marital relationship. Even live-in couples, once they separate, then there is still an entitlement to maintenance. So whether two people were in a live-in relationship or not, maybe the security guard or the maid or the neighbor is in a position to help the court decide. That's one example. Let us take another. Succession. Okay. Let us say there's a person, this person dies intestate. What does that mean? He dies without a will. Okay. So now his property has to go to his successors. And his successors are basically his relatives. So you have to find out as to who his relatives are. And therefore, again, forming an opinion on relationships becomes important. Okay. However, you look at the proviso to section 50. It says that such opinions shall not be sufficient to prove a marriage for proceedings under the Divorce Act or in prosecutions under 494, 495, 497 or 498. So 494 and 495 deal with the offense of bigamy or polygamy, whatever you like to call it. 497, well, that has been struck down already, and therefore it's not something we need to talk about. But previously it spoke about the offense of adultery, which has been recently struck down, and 498, which is the enticement of a married woman. 498. Okay. So what it says is that the opinion in these cases will not be relevant. For other things, like I said, for example, succession or for maintenance, it will be relevant. Let's have a look at illustration B. The question is whether A was the legitimate son of B or not. The fact that he was always treated as such. What is the meaning of as such? He was treated as a legitimate son. That's what the meaning of as such is. So the fact that he was always treated as such by the members of the family is relevant. I want you to pay attention to one important word here and then think about it as to why I have pointed out that to you and where it is significant in the statute, in that section. That important word is this word treated, which I have highlighted for you here. So what is the significance of this word treated in here? What if they had simply said that, okay, A is my son? What is the difference between treating A as the son and just maybe perhaps saying it once that, okay, A is my son? What is the difference between the two? And does the statute make a distinction between these or not? Let me know in the comment section, right? My question to you basically is, what would have been the difference between treating him as a son and simply maybe once calling him as the son? And why is this distinction between treating, which is basically to do something, and on the other hand simply saying it? What is the significance of the distinction between these two? Let me know in the comment section. In today's lesson, we will be seeing just two more provisions. We look at section 51, grounds of opinion when relevant. Whenever the opinion of any living person is relevant, so when the opinion of a person is relevant under 45, as we just saw, 47, there's also 46, I didn't discuss it, but you can read it. 48, 49, again, we didn't discuss, but we read it. We saw 45, 47, and 50. So basically, whenever the opinion of a person is relevant, the grounds on which such opinion is based on is also relevant. So for example, you can look at the illustration. An expert may give an account of the experiments performed by him for the purpose of his opinion. So as you can see here, the opinion is a matter of science, but his opinion is based on his experiments, right? So his experiments are basically the grounds on which his opinion is founded. So the grounds on which he forms his opinion are also relevant. Okay, that's what section 51 tells you. Now we have a look at section 46. Facts bearing upon the opinion of experts. Pause the video for a moment, read this, and then tell me in the comment section whether this reminds you of another section that we have studied until now. You can let me know in the comment section whether this reminds you of something. Okay, it's very simple. Facts which are otherwise not relevant become relevant because they either support or are inconsistent with the opinion of experts. So you can have a look at the illustration. Pause the video, read the illustration first. I'll give you a brief explanation. The question is whether A was poisoned by a certain poison. Whether A was poisoned by a certain poison or not. The fact that other persons, let's say you had other persons B, C and D. You had B, you had C and you had D. The fact that other persons who were poisoned by that poison exhibited certain symptoms, which experts affirm or deny to be the symptoms of that poison, is also relevant. Okay, let us say an expert here, okay, an expert for A said that when you consume this poison, then perhaps you would have, let's say you have a foaming mouth. As you are aware, sometimes when poison is consumed, then there is foaming that happens at the mouth. Let us say this is the opinion of the expert, which is obviously relevant. But let us say B, C and D, okay, B, C and D also consume the same poison, but they did not show these symptoms. So what does that do? It becomes inconsistent with the opinion of the expert, okay, and therefore, although otherwise it is not relevant, as you can see here, though otherwise not relevant, because B, C and D are not important as far as our present case is concerned, but because the cases of B, C and D to some extent or to completely are inconsistent with what was said about A, it can become relevant. Likewise, let us say an expert had said that you will have a foaming mouth, and B, C and D also have a foaming mouth. What does that do? It affirms, it supports the opinion of the expert, so that also becomes relevant. So facts otherwise not relevant become relevant. Okay, so with this we've seen most of the provisions between 45 and 51. Whatever we've not seen, you can go and have a look at them by your own self. I hope this lesson was of use to you. Thank you so much for your time and patience. Good day.